Okay, thank you. So today we have once again gathered for two of the most important session for Clat 2022 and Clat 2023. That is the Pakistan crisis, which is very important from international perspective, and from national perspective we have AFSA and all you need to know about it. So we will be discussing this two important issue. We had already covered the Sri Lanka crisis, which is another very important international for your Clat 2022 and 2023. Now in this session we are going to discuss these two important national and international event. So I hope you are sitting with your notebook and pen, and without wasting time, let us start and move to the first slide. So you must be updated what all happened in Pakistan in the last few days, what all happened from the parliament to the Supreme Court, that we are going to discuss from the history to till the present, that today as of now what is the situation in Pakistan. So let's start with the session. First of all, we have to understand that what happened actually, because of which we are facing the current situation. Now, on 8th of March 2022, the opposition party of the Pakistan has brought a no confidence motion against the now he has become the former prime minister, that is Imran Khan. So what is the reason for which they brought the, you have to understand guys, step by step every event, the list of event that has happened in Pakistan, then only it will be easier for you to know and understand what has actually happened. Okay, so on 8 March, the Pakistan opposition, as we all know, the what is no confidence motion. So the no confidence motion means when the opposition believes that the government is not able to actually control everything in the country, the government is not able to work according to the constitution, or the opposition feels that the government doesn't have the actual number which it requires for majority. So if for example there is a an assembly of India which is having 545 seats, we have a majority mark at 302 for example. So what is important here is that the whichever government wants to form a government in that particular country, they have to have the at least the majority mark, then only it will be possible for them to form the government. Same thing happened in the Pakistan because of the inflation, because of the economic situation that was going on in the country, and for all this reason the opposition of the Pakistan had brought the no confidence motion in the country, demanding the resignation of the prime minister, that is Imran Khan. So first you have to understand the reason. The reason that was given was the inflation, and the government failed to control the inflation. As you know, the prices of tomatoes, you know the prices of fuel, you know what is the economic condition of Pakistan that is in present. So this is the Pakistan. This is the first thing that you have to know, that the no confidence motion was brought by 100 lawmakers from two important parties. So what you have to know here, that as per the rules of Pakistan, 68 members of parliament are required for bringing a no confidence motion and forcing the speaker to summon the house for the voting on the same no confidence motion. So as we all know, even if we know from the constitution perspective, that when a no confidence motion is brought, the speaker will admit the no confidence motion, after which there will be a voting, and if the no confidence motion gets the support, then the government have to resign from not only the prime minister but including his cabinet minister, and the whole government falls. So in Pakistan, as per the rule, 68 members are required to initiate the no confidence motion, but not 68, there were 100. There were 100 lawmakers who brought the no confidence motion in the Pakistan assembly from the two party. That is very important for you to know, that is the Pakistan Muslim League Nawaz and Pakistan People's Party. These are the two parties of whose 100 lawmakers, they submitted the no confidence motion to the National Assembly Secretariat, and then the no confidence motion was submitted in the National Parliament of the House, and as per the rules, between 3 to 7 days. So for example, on 12th of April today, the opposition brings a no confidence motion, then from 3 to 7 days, between 3 to 7 days, it is important for the house to vote on it. It is important for the speaker to get a voting on the same. So this was the no confidence motion which was brought. And then the important thing is that the present government, the last government of Imran Khan, it was a coalition government. It was not a majority party government as we have in India, that the BJP alone is having more than the majority mark, but Imran Khan government was having Imran Khan was a coalition government, so it is very easy for the defection to happen. As we all know, the anti-defection law is there in India, and even in other country also there are some laws. But it is very easy to switch the sides. So definitely, the opposition was having such majority that it would be required to prove the no confidence motion, and so they brought the no confidence motion because according to them they have the support of 177. So the Pakistan National Assembly is a house of 342. This is important point from your Clat perspective. You will be getting this in the comprehensive passages question, that the House of Pakistan is having 342 assembly house, in which to bring a no confidence motion or for the majority you are required to have 172. The opposition were claiming that they are having 177, which is more than the majority mark, and so they brought the no confidence motion in the Pakistan Assembly. They submitted it to the speaker, and then it was to be voted between 3 to 7 days, but it did not. And what happened then, we will be noticing. So I hope it is clear, guys. You are okay with my speed, everyone? If you need, I will be little bit slow down my speed, but I hope it is okay for everyone. Let me know in the chat box. Okay. Okay, good. So you have to, what you have to remember from this point, that the two party you have to remember, and it is a 342 assembly house in which 172 is the majority, out of which 177 were supporting the no confidence motion according to the opposition. Let's move to the next slide. Now let's understand the no confidence motion of Pakistan. Okay. Now the no confidence motion was initiated in the House. However, the Deputy Speaker of Pakistan National Assembly, the name is very important, guys, for your examination, that is Qasim Khan Suri. Qasim Khan Suri dismissed the no confidence motion because, according to the Deputy Speaker, the no confidence motion was unconstitutional and it violated Article 5 of the Constitution of Pakistan. Now we will understand what is Article 5 of the Pakistan Constitution. That is next point. But before that, you have to know the name of the Deputy Speaker. That is Qasim Khan Suri is the name of the Deputy Speaker, who dismissed the no confidence motion because, according to him, it violated Article 5 of the Pakistan's Constitution, and so it is unconstitutional. Why? Now let's understand Article 5. This is also very important. Article 5 talks about two clauses. The first clause says that every citizen has to be loyal to the state, that is the state of Pakistan. Here state does not mean Gujarat, Maharashtra, Jharkhand. No, here state is your Pakistan. In the international law, the state is India, Pakistan, America. These are the different states. So, according to Article 5 of the Pakistan Constitution, guys, it has two clauses. The first is that every citizen has to be loyal to the state, and second, the obedience to the Constitution is the obligation of every citizen who is within Pakistan. So, even if you are not a citizen, so it is mentioned that every other person for the time being within Pakistan. So, even if tomorrow Utsav is in Pakistan, although Usav is an Indian citizen, or we have Anshita, or any one of you, if you are tomorrow in Pakistan, you have to follow Article 5 Clause 2. You have to obey the Constitution of Pakistan according to Clause 2. So the Deputy Speaker of Pakistan National Assembly used to use this article, that is Article 5 Clause 1, and told that the loyalty of the state has been violated by the opposition because they have conspired with the foreign nationalist foreign countries to dismiss our government. So the speaker told that because the opposition broke their loyalty, they are no more loyal to the constitution, they are no more loyal to our country. Therefore, we are using the Article 5. There is a violation of Article 5, and there is a foreign conspiracy against the government. And so the speaker dismissed the no confidence motion. So as you can read from the slide, that there is a foreign policy against the government. He said the no confidence motion was a conspiracy hatched by powerful country that did not want Pakistan to have an independent foreign policy. Is there a network issue, guys? Ankit, Utsav? Okay, little. I will be changing my. Oh, just give me a minute. Okay, just give me a minute, guys. Okay, is it fine now, everyone? Okay, good. So, what I was telling, yeah. So, Article 5, Clause 1 was used by the Pakistan Deputy Speaker and told that there is a violation of Article 5, Clause 1 because, according to Fawad Chaudhry, the minister, he told that there is a foreign conspiracy that is being hatched against the government of Pakistan, and so the Deputy Speaker told that we are not going to allow this no confidence motion because of the violation of Article 5, Clause 1. Okay, so what you have to note from this slide, who is the Deputy Speaker, the article that was being violated according to the Deputy Speaker and the ministry, and then what are the two clauses of that article. Now let's move to the next slide. Now, what is the Pakistan opposition saying? So, previous slide we discussed the why the no confidence motion was dismissed and what was the reason for the Article Clause 5(1) being violated. Now, let's understand what the opposition is saying. So, according to the opposition, that the prime minister, the minister and the speaker has violated the clause 2, which demand the obligation to the constitution of every citizen. Said they told that the constitution, it is very clearly mentioned in the Pakistan constitution that a no confidence motion can be brought by the opposition. The no confidence motion has to be voted between 3 to 7 days. These are very important point for your Clat examination when you are having comprehensive current affairs. So the no confidence motion has to be voted between 3 to 7 days. The Pakistan Deputy Speaker did not had a vote, did not summon the House for the voting, and so they violated the second clause of Article 5, that is the obedience of every citizen. Leave apart Utsav and Ankit as a person in Pakistan. Okay, you are there as a person, that is okay. But you, Imran Khan, and all your minister and even the Deputy Speaker, you are the citizen and you have to obey the constitution which you violated. And so they told that the Deputy Speaker and Imran Khan and his whole government should be tried under Article 6 of the Pakistan Constitution, that is treason, which says that any person who subverts or conspires to damage or modify or dominate the constitution by unconstitutional means shall be guilty of treason. So the government, the previous government, the last government of Imran Khan used Article 5 Clause 1. The opposition used Article 5 only, but Clause 2, which talks about the obedience to the constitution. And then they told that the Pakistan Prime Minister, Deputy Speaker and the government should be charged under Article 6, that is treason, which talks about the unconstitutional method for damaging or destroying or conspiring against the constitution. Is it clear, guys, to everyone? This is just the history of what had happened. So the no confidence motion was brought. The Deputy Speaker dismissed under Article Clause 5(1). The opposition shouted. They told that it is against the constitution because of Article Clause 5(2). Everyone, it is clear, guys? And hope I am audible also to everyone. Okay. Now let's move to the next slide. Now come to the dissolution of the National Assembly. So the Pakistan Deputy Speaker did not admitted the no confidence motion, but there was no voting on the no confidence motion because of Article 5. And leave apart the voting, after which the Prime Minister advised the President, the name of the President is very important, that is Arif Alvi. Arif Alvi dissolved the National Assembly of Pakistan, which is known as Majlis-e-Shura, under Article 52 of the Constitution. So the Pakistan Prime Minister advised to the President, that is Arif Ali, that sir, you dissolve the House, it would be the best option that we are having as of now. Under Article 52 of the Pakistan Constitution, we can dissolve the House, that is the House name is Majlis-e-Shura. And then it is mentioned in Article 52 of the Constitution of Pakistan that when the House is dissolved, in any case the election has to be held from 90 days from the date of the dissolution of the House until and unless the court intervenes. This is very important point, because as we all know, you must have read also the Pakistan issue, the court had intervened, but it told that according to Article 52 of the Pakistan Constitution, that if the House is dissolved, from the day the House is dissolved, within 90 days the general election of the country has to be carried out until and unless the court intervene in the matter, which happened in the Pakistan issue that we will be noticing in the next slide. So this is the dissolution of the house. This is very important, guys. Can anybody let me know which article of the Indian Constitution talks about that the president is bound to act on the aid and advice of the Council of Ministers of the Indian Constitution? Which article of the Indian Constitution talks that the president is bound to act on the aid and advice of the Prime Minister? Research on it because it is important for your Clat examination also, and let me know. Okay, so Google it and let me know. No issue. So this is the thing. The after the see no confidence motion brought in, Deputy Speaker did no vetting. Yeah, Ankit, you're right. Yeah, so also right. The Deputy Speaker did not got a vote on the same on basis of Article 5, after which Pakistan President dissolved the Majlis-e-Shura on the advice of the Prime Minister Imran Khan under Article 52. This is done. These are the list of events. You have to connect all the dots. After which, what happened, guys? After the house was dissolved, the Pakistan Supreme Court took so motto of the matter and asked the state machinery, that is the executive and the legislative, to stop working and stop taking any unconstitutional steps till the matter is sub judice. So now the matter definitely, as our apex court, they have their apex court, and the matter finally reached to the Supreme Court of Pakistan. They took the so moto matter in spite of other petition that was so moto. I am telling you, so moto, they took the matter in spite of other petitions. So what happened, Utsav? I am telling you. Now the Supreme Court of India has been given this power. For example, if you remember the Lakhimpur village case, do you remember the farmer protests and the one of the ruling party son was alleged that he run the farmer? Do you remember, guys? Yeah. So in the same as the Lakhimpur village, or in many matter, when the matter is of very important issue, for example national issue, or the matter require an immediate concern, in that case there is no required of any petition. So it is not important that Sachin will go and file a petition in the Supreme Court, or Akshar or Sushant will go and file the petition in the Supreme Court. If Muhammad Ali Ahmad is the Chief Justice of India, he will so moto take the matter. Under our Indian Constitution, they have been given the power that they will so moto take the matter, and then they will be asking the Attorney General or the Advocate General to present the facts of the case. This is the meaning of so moto. So there is no need of any petition. Automatically Muhammad Ali Ahmad will be taking the matter and he will start discussing on the matter, and then he will give it the judgment. This is the meaning of so moto. Is it clear, Ussav and everybody, guys? So the Pakistan Prime Minister, in spite of other petition, it took so moto because it is such a matter, because the assembly is dissolved, the no confidence motion was not voted, and there is a crisis in the country. So after which the matter was taken so moto, and the state machinery was asked to stop taking any unconstitutional step till the matter is sub judice. Next slide. So Pakistan Supreme Court started discussing the legality of how the Prime Minister dissolved the assembly. There was no voting on the no confidence motion, and a 5-member bench headed by not Muhammad Ali Ahmad, but the real name is Umar Ata Bandial. He heard the matter. They heard the matter continuously for 5 days. So the name of the Chief Justice of Pakistan who heard the matter is very important, guys, for your examination. That is Umar Ata Bandial. A 5-judge constitution bench headed the matter, and continuously for 5 days the matter continued. Now let's understand the contention of the both the parties. According to the Prime Minister lawyer, okay, so for example, Anshita is the lawyer of Prime Minister representing the Prime Minister in the court of Supreme Court. He told that the court cannot, neither in the past nor in the present, until and only unless we have Article 69 in the Pakistan Constitution, the court cannot interfere in the proceeding of the House. This is very important. In Indian Constitution also we have the similar provision that the proceeding of the Lok Sabha and the Rajya Sabha will not be called in question in the court of law. But now we are having different judicial review after the anti-defection law and all. Let's talk now about Pakistan. According to 69 of the Pakistan Constitution, the court cannot interfere in the proceeding of the House. So as you can read from the slide, the court has not interfered in the proceeding of the Parliament in the past, and the proceeding of the House are beyond the jurisdiction of the court. Under Article 69 of the Constitution of Pakistan, the ruling of the Speaker could not be challenged. This was the contention of the Prime Minister lawyer. For example, we have Anshita is the Prime Minister lawyer representing the Prime Minister. Now let's move to the next slide and understand that what was the contention of the opposition. It is not mentioned here, but I am telling you the opposition contention was the same that we discussed in the that slide, that it is a violation of the constitution. This is a grave injustice, this is a very grave issue, the country is facing a very big crisis, and therefore we need the matter to be taken up in any circumstances. So although article 69, no proceeding of the house will be taken into consideration, but chief justice, this is a very important matter, it is taking into consideration the gravity of the situation. Chief Justice of Pakistan told that it is a prima facie violation of article 95. Don't confuse in this all these article guys while solving the questions or in the mock or in the Clat examination. Article 95 of the Constitution of Pakistan states that when a no confidence motion is brought in the house, it should be voted within 7 days of its inception. So if today the no confidence motion is brought on 12th of April, within 7 days it has to be voted by the speaker. So the Pakistan Chief Justice on the first day of the hearing only guys, he told that this is the prima facie. He did not went into the case fully. He told that prima facie the case appeared to be a violation of article 95, and so this case will be taken up. We will be discussing all the issues that the speaker and the prime minister had done. The Pakistan Supreme Court called the election commission. The election commission told that as per the country's laws and everything, we will be needing 6 to 7 months to conduct our election, because we have decided for the delimitation and all those issues. So definitely we will be requiring 6 to 7 months. But guys, let me know in the chat box, according to the Pakistan constitution, after the dissolution of the house, within how many days the election has to be conducted? I want everyone to answer. Sushant, Akshar, Soha. Within how many days, according to the Pakistan constitution, the election has to be conducted? Very good. So, but the election commission informed the court that, sir, we need 6 to 7 months because we have to conduct the delimitation, and then only because it is a nationwide election, we cannot do it immediately. This was the contention of the election commission, and already the Chief Justice of Pakistan has said that the Deputy Speaker action is prima facie violation of article 95. What judgment did the Supreme Court give? You all know. I hope that you all know the judgment that the Supreme Court of Pakistan gave. Supreme Court termed the dismissal of the no confidence motion as unconstitutional. As we discussed in the first point of this slide, already on the first day of the hearing, already the Chief Justice has told that this is a prima facie violation because you are violating article 95 of the Pakistan constitution. And that was the judgment that all we knew that would be coming after the 5-day hearing by the constitution bench. They told that the no confidence motion that you dismiss is unconstitutional where you have dismissed, and the Chief Justice, the Supreme Court ordered the restatement of the National Assembly. What is the name of the National Assembly, guys? Pakistan National Assembly. And then the Supreme Court allowed the opposition, the Supreme Court granted permission to the opposition to again have a vote on the no confidence motion. Very good. So again have a vote on the no confidence motion. Now let's understand further. After the decision of the Supreme Court ordered that the opposition have to get a voting on the no confidence motion, and then the no confidence motion was again tabled in the National Assembly. But it was tabled in the National Assembly so that it should be voted according to the direction of the Supreme Court. But Pakistan Prime Minister Imran Khan had a cabinet meeting, and he straightforward he told that I am not going to resign in any circumstances. I will be on the pitch. Okay, you know Imran Khan is he's a cricketer. So Imran Khan told that I will be on the pitch. You do whatever you want. I am not going to resign. Because of this, the Supreme Court and the Islamabad High Court told that if such is the matter, we open the court door at midnight 12 a.m. So there was a deadline given to the speaker that before 12 a.m. the speaker has to get a voting on the no confidence motion. The Pakistan Supreme Court and the Islamabad High Court, seeing the matter, the gravity of the situation, they opened the door in the midnight at 9:30, around 9:30. They opened the door and told the opposition of Pakistan that if you want, we can again have a start the hearing as of now on a contempt petition. After all this high drama and before the deadline of the voting, the speaker and the deputy speaker of the Pakistan resigned. After all this high drama, the speaker and the deputy speaker of Pakistan, they resigned from the house. This is a very common thing. कुछ भी नहीं हो रहा है तो resign कर देते हैं. But as you know, we have even in the Indian Constitution and even in the Indian Lok Sabha also. Can anybody tell me that if the speaker and the deputy speaker resign, who will preside the chair? If it is difficult to type, you can unmute also. If the speaker and deputy speaker resign, who will be taking into consideration who will be presiding the chair? If you don't know, guys, let me know. I will be letting you know. Acha, okay, very good. So, okay, good. So the speaker and deputy, when the speaker and deputy speaker resign, guys, remember it for your lifetime now. Even in the constitution, in the law school, you will be reading this. That when the speaker and deputy speaker resign, from among the member, one of the member is elected to the chair. Okay, it is not someone. For example, guys, if the president and vice president resign, who will become the president? Can you tell me this? If tomorrow the president and vice president Ramnath Kovind ji and Venkaiah Naidu ji resign, who will become the very good, Anshita? So it is the Chief Justice of India will become the president. But in the case of speaker and deputy speaker, yeah, good. In the case of deputy speaker and speaker, no one will be coming from outside. It is one of the member from the Lok Sabha or Rajya Sabha only. He will be elected to the chair. Okay, so the speaker and deputy speaker resign. So sir, आप resign कर दे रहे, इससे कोई अंतर नहीं पड़ने वाला है. We will be getting another person to be on the chair. Before the deadline they resign, but in spite of all the things that Imran Khan could do, the no confidence motion was voted. The Pakistan Prime Minister party, that is Tehreek-e-Insaf party, को इंसाफ मिल गया forever, and the joint opposition secured the support of 174 member in the House of 342. So they required 172, they got 174, and as a result, the no confidence motion was passed. No confidence motion passed means the Prime Minister, along with the whole cabinet, Council of Minister, Minister of State, and the whole government fall down. They automatically have to resign. So you have to remember the name of Imran Khan party, that is Tehreek-e-Insaf party. Remember in this sense that Aaryan Bhaiya has told in the class that you will be that the party got insaf after the no confidence motion. So you have to remember the name of the party. Is it clear till here, everyone, guys? Now let's move to the next slide. Everyone, it is clear, guys? Previous slide. After the no confidence motion was passed, okay, after the no confidence motion was passed, Shehbaz Sharif was nominated for the Prime Minister post, and yesterday he got elected as the Prime Minister of Pakistan. Which number Prime Minister? Anybody? Let me know how much you are preparing for Clat. Shehbaz Sharif is the which number Prime Minister of Pakistan? If you don't know, search it on the Google and let me know within the next 2 minutes. So Shehbaz Sharif was nominated, and yesterday he finally got elected as the Prime Minister of Pakistan. And you have to know the other name here also, that is the Imran Khan party, that is Pakistan Tehreek-e-Insaf. They got the ex-foreign minister, that is Shah Mahmood Qureshi. It was their face. Okay, Shah Mahmood Qureshi was their face, that is PTI for Shah Mahmood Qureshi, and for the opposition it had Shehbaz Sharif, and he was elected the Prime Minister of Pakistan. This is the whole scenario, guys, from the initiation of the no confidence motion. Deputy Speaker, name of Deputy Speaker, article that the Deputy Speaker used, article that the opposition used, and then it was the Supreme Court, under which article Supreme Court was barred from having a discussion, however Supreme Court used which article, and finally who got elected as the Prime Minister, which number Prime Minister, name of party of Imran Khan. Now let's move to the next slide, and definitely we have to connect it with India and understand the no confidence motion in India. So when a no confidence motion is brought in our Indian Parliament, then the Prime Minister, his Council of Ministers has to resign automatically after it is being passed. Okay, after they are no longer, they are considered to be fit for the responsibility of carrying out the obligation. So let's next slide. So the no confidence motion in India, you have to know before you go for your Clat examination. Next slide, Kanishk. Yeah. So the no confidence motion can be introduced under the Lok Sabha Rule 198. That means under our Indian Constitution, there is nowhere. This is very important, guys. That under our Indian Constitution, there is nowhere mention about the no confidence motion. We have Article 75. That is the Council of Ministers shall be collectively be responsible to the Lok Sabha. So if tomorrow a no confidence motion is brought in Indian Constitution, then what will happen? The council of minister and the prime minister has to resign, as I have already told you. So similar thing here, we do not have in the Indian constitution, unlike the Pakistan constitution under article 52. In the Indian constitution, there is nowhere mention about the no confidence motion. Either we have the Lok Sabha rule 198, which states that a motion of no confidence motion can be admitted when a minimum of 50 members support the motion. In case of Pakistan, we have how many, guys? How many support was required according to the Pakistan constitution? 68. 68 was required in the according to the Pakistan constitution. 68 was required according to the Pakistan constitution. According to Indian Lok Sabha rule, we required 50 members to support the no confidence motion, and then there will be voting. And as we discussed from the last half an hour, the same provision will be carried out here also. Next slide. Okay, stop. So guys, I hope the Pakistan issue is clear to everyone. Let me know in the chat box fast. Pakistan issue is clear to everyone. Okay. So this is an important international issue. You whatever you have to remember already I have told you. Now come to another very important national issue, that is the AFSPA, that is the Armed Force Special Power Act. A major change was brought recently by the Home Ministry after all the violent protests and the difference of opinion between the northeastern state. A major change was brought in this after a long decades. So let's understand the whole AFSA and why it is in news, what it is, and why it was withdrawn. Let's understand with the first slide. So what happened, guys? This is very important. The union government has partially, so as a law student it is very important. For example, tomorrow someone asks to Manas or Anshika that what happened, you are a Clat aspirant, tell me what is happening in AFSPA. It should be very clear to Manas, Anshika and everyone, whoever is in the class, that actually what is happening in AFSPA. If you ask a common layman, no guys, they will be telling AFSPA हट गया, AFSPA जो है होम मिनिस्ट्री ने हटा दिया, यूनियन गवर्नमेंट ने हटा दिया. नो गाइस, AFSPA has been partially withdrawn from part of 3 northeast Indian states, that is Assam, Nagaland and Manipur, and it remained in part in these 3 states and in full part of Arunachal Pradesh and Jammu Kashmir, as was the situation before this date. Okay, so this 3 states you have to remember, and other 2 states in which AFSPA is there you have to remember. So partially it has been removed from Assam, Nagaland and Manipur, and it is as usual as the status quo is maintained in Arunachal Pradesh and Jammu Kashmir. Next slide. Now with this image, let's understand what has actually happened with the AFSPA in this 3 states. So we understood in Assam, Nagaland and Manipur it has been partially removed. These points are very important. In Assam, let's discuss first. As you can see from the map, from the 23 districts, the AFSPA has been fully removed, and it has been partially removed from 1 district. Okay, partially removed from 1 district. It remained in force in 9 districts. So fully it has been removed from 23 districts, partially it has been removed from 1 district, and in 9 districts still AFSPA is there. Okay, but the good thing is that the withdrawal area, the area from which it has been withdrawn, covers 60%. Statistics is very important, guys. Don't think that I am just included this diagram for your information. This is important for your Clat questions. You will be getting a direct questions. This will be the 3 options that you can see on the slide. So Assam 23, you have to remember 23, 1 and 9. 23 it is fully withdrawn, 1 is partially, and 9 is still in Assam, 9 district. If we talk about Nagaland, totally it has been removed from 3 districts and partially from 4. Withdrawal area covered 25%. Be quick in making notes, guys. And then we have Manipur. In Manipur only partially it has been lifted from the 6th Valley district, and in the hilly region still is there. So this is the slide you have to remember. In Assam, in Nagaland and Manipur, these are the 3 states from which partially, impartially, fully, whatever it is, how in the district, the AFSPA has been recently being removed. Now let's move to the next slide. Okay, guys. Before that, before going to the next this slide, let me know the Chief Minister of Assam, Nagaland. Search it and let me know. Who is the Chief Minister of Assam? Who is the Chief Minister of Nagaland? Who is the Chief Minister of Manipur? These are very important questions. These are not mentioned in the slide. Everything we cannot cover in the slide. So let me know. Search it on the Google and even add it to your notes. Let other people know. Utsav, Ankit, any one of you. Let us know who is the Chief Minister of Assam, Nagaland and Manipur. Now let's understand the background of AFSPA. AFSPA was introduced by the British government on the 15th of August 1942. Not by the name of AFSPA, it was the name of Armed Force Special Power Ordinance, which was brought to suppress the Quit India movement. So if you remember, guys, the Quit India movement, okay, it was for the same. Assam, we have Himanta Biswa Sarma. Meghalaya is Conrad Sharma. Nepuru is of Nagaland. Okay, very good. Very good, this stuff. Guys, this is Manas also, very good. So you have to mention this in your note wherever you are taking the notes, because it is important for your Clat examination. So this is one of the draconian law, according to the other people, that this is one of the draconian law similar to Article 124A. What is 124A, guys? 124A, the draconian 124A, what it is? So on 15th August 1942, an ordinance was brought. Yeah, good. Manash. Okay, guys, very good. You all have mentioned the name of the CM. So an ordinance was brought by on 15th of August by the then British government, that was to suppress the Quit India movement. And then after all this, finally we had the AFSPA. Okay, so in first you have to remember the first date, that is 15th August 1942, and finally we had the Armed Force Assam and Manipur Special Power Act, that is 1958, which following which we had the Assam Disturbed Area Act 1955, and after all this background we had the final, that is AFSPA Act, which is used as of now. So apart from all the ordinance which was in the past, as of now we have AFSPA. We had Armed Force Assam and Manipur Special Power Act, but because of for this wide application we have one single AFSPA. Okay, this is the background of AFSPA. Next slide. Now, what is AFSPA actually? So AFSPA gives a very wide power to the armed forces. They can do a open fire, they can cause hurt to any person who goes against the law, to the security forces, to the armed forces. A wide power is given by the Union government or the Home Ministry, that you can even cause the death of any person if you think that it is the need of the hour, which we have seen from the last 10 years, that there is a violent protest against the same because of the same reason. Very recently, you have seen there were death of the civilians because of the same AFSPA. So a wide power is given to the armed forces. They can arrest the people without any warrant, and only on the basis of suspicion. If they think that there is a reasonable suspicion, the people can be arrested. They can enter the premise of any family, search in there whether it is women or not. They do not take into consideration the CPC provision that you cannot directly enter the house of a pardadari woman. These all things are not taken into consideration in AFSPA. They directly enter and search any premise. They can arrest any person without any warrant. Now, according to Section 3 of the Act, any of the area of this northeastern state in which AFSPA is being brought by the central government or the state of the by the governor, they can declare an area as a disturbed area. So AFSPA can only be used when a particular area of Assam or when a particular district of Nagaland or Manipur is declared as a disturbed area. Disturbed area means there the area is not going according to the provision of the constitution. In that case, area is declared as a disturbed area by the union government or on the recommendation of the state government. Okay, guys. So this is the AFSPA, which gives a wide power to the armed forces. They are not questioned in any court of law. The main thing, they can arrest the people without warrant. They can only arrest a person if there is a suspicion. Next slide. Now, before 1972, the central government and the state government can declare an area as a disturbed area under Section 3. But in 1972 there was an amendment made in section 3, and it was mentioned that it is only the central government upon the central government who will decide, but they will take into consideration the recommendation or the suggestion of the state. Okay, before even the state could declare AFSPA, but after 1972 it was made concurrently. If you know the state list, union list and concurrent list. So in 1972 an amendment was made, and it was told that the central government along with the state government, in consultation with the state government, they can declare a area as a disturbed area. Okay, and it is the home ministry. So if you get a question tomorrow that which ministry is responsible, for the declaration of an area as a disturbed area, it is the home ministry. And who is the home minister of India, guys? Anshita, Sushant, who is the home minister of India, present home minister? Okay, so the home minister of India can issue a periodic notification that a particular area is a disturbed area for the state of Nagaland and Arunachal Pradesh. But in the case of Manipur and Assam, it is only by the state who issued the notification. The two difference, guys, understand this thing. For Nagaland and Arunachal Pradesh, it is the Home Ministry, Amit Shah. Okay, the Home Ministry will be issuing a notification that a particular area of Nagaland or a particular area of Arunachal Pradesh is declared to be a disturbed area. It is the Home Ministry which will be issuing the order. But for the case of Manipur and Assam, the power has been given to the state government, that it is the state government which will be declaring that whether a particular area is a disturbed area or not. Okay, and very important thing is two states, that is Meghalaya and Tripura. So Tripura revoked the AFSPA Act in 2015 and Meghalaya revoked it in 2018 on 1st April 2018. This too is very important for question for your Clat examination. The two states which revoked AFSPA, it is Tripura and Meghalaya in 2015 and 2018. We have in force in Nagaland, Arunachal Pradesh, Manipur, Assam, and now we have in even in Jammu Kashmir after the latest all changes in the Article 370. Okay, guys, let's slide. Now, what is the role of the state government? This is very important. The Act gives the power to the central government that you can unilaterally declare a area as a disturbed area, but as we read in the previous slide, article after 1972 amendment, it is important for the central government to have a consultation with the state government. Okay, even if the governor of the state is giving a suggestion to the central government, they have to take it into consideration. This is very important, and it is the state government only who have a contact with the local police. So the local police is very important place here, because the security force, as we read in the last previous two slides, that the security force is having the power to arrest anyone whom they have a suspect. They can arrest them without any warrant. But whoever is arrested under AFSPA by the security force, they have to be handed over to the local police within 24 hours. So it is the duty of the state government to have a cooperation and coordination with the local police, that whether the security forces are giving these people to you within 24 hours or not. And all the security forces have to work according to the district administration and not as an independent body, as it is mentioned in the slide. So within 24 hours of the arrest of an individual, they have to be handed over to the local police, and there comes the role of the state government, because the state government is very important, because after the 1972 amendment, they have to take the consideration of the state government, they have to take into consideration the suggestion of the state government, and then it is the local police with whom it is only the state government has the coordination. So it is important of the state. Next slide. Now let's understand why the AFSPA has been withdrawn now and what is its impact. This is very important. The first reason that is given by the union government for the removal of AFSPA in this area is that now this area are no longer a disturbed area. We declare area disturbed area and then only we impose AFSPA there. But because the security of this area has improved, there is a lot of development in these areas, and a lot of agreement has been held in all this area. Therefore, we are no longer taking this area into a disturbed area. Therefore, for all this area, AFSPA has been removed. As we all know, recently there was an agreement signed between which two state, guys? Let me know. Between which two state government with the central government has signed an agreement? for the issues that was, yeah, very good. Meghalaya and Assam. So, according to the union government, yeah, Meghalaya and Assam has recently signed a government has signed an agreement also for the because of all the insurgency that was going on between these two between these two states. So there is an agreement, and then we have the this is very important, that is NSICN, that is Isak Munia and the Naga National Political Group. They are all having a very important agreement that is going on. If you remember Clat 2020, there was that time it was a very debatable issue of the Nagaland, where an agreement has been concluded, but still the agreement has not taken into force. It is not in force. So according to the union government, the NSIN, that is the Ishak Munia and the Naga National Political Group, they are at the advanced stage of the agreement with the state for all the issues that is going on in the disturbed area, and therefore no longer the AFSPA is required on this area. Now, why one of the reason for the removal of this is the people of this state or of this disturbed area, they feel that they are alienated from the rest of the country. Just we had Article 370 in the similar manner. There, no one could enter there. The police could use a lot of force. The armed force can arrest anyone. So the people of this area were thinking that we do not have a normal situation in our area, and thus they feel they were alienated from the rest of the country. So the reason, if you are asked in the examination that what is the reason for the removal of the AFSPA, is that the security has been improved in this area, and the people of this area, after 60 years of this draconian law, draconian act, the people of this areas feel they are alienated from the rest of the country. Next slide. So as I've already told you that the people of the people can be arrested without any warrant. There is fake encounter that is going on in the state. The decision, they are not going to the Supreme Court. They are not challenging the Supreme Court. The security forces are given a very wide power to be used, as a result of which there is lot of extra killing that is going on in this state, and the people are feeling they are alienated from the rest of the country. And as we have discussed in the last slide, the two states, that is Tripura and Meghalaya, has already revoked this law from their state. And as you can see, in a writ petition filed in the Supreme Court in 2012, the family of the victims of extrajudicial killings alleged that 1528 fake encounters had taken place from 1979 to May 2012. Okay, and the Supreme Court set up a committee for the searching of or taking an investigation into 6 cases, and all the 6 were a fake encounter. So you can understand, guys, such a law it is, such a power it is given to the security force, and because of all this reason, because of the long protest that is going on from the decade, the government slowly, not immediately, but the government slowly is revoking this law back. Next slide. These 3 are very important thing that you have to remember, that before this, the government decision of revoking it from some part of the some of the disturbed area, there was a protest by Aaryan Sharmila. This is very important. In 2000, an activist called Aaryan Sharmila, she started a hunger strike for continuously 16 years to remove the AFSPA from Manipur. This is very important point. The name of the activist, Aaryan Sharmila, started a hunger strike for the 16 years to end the AFSPA in Manipur. Then we had the setting up of the Justice Jeevan Reddy Committee, which told that AFSPA is an undesirable, there is no need of AFSPA in our country, and they told that we have to, the central government should revoke the law, the central government should give up, the central government should give up the law. The second, Administrative Reforms Commission recommendation, same thing, you have to know the name who headed the commission, that is Virappa Moily. They also told the same thing, that the second Administrative Reform Commission told that the recommendation given by the Justice Jeevan Reddy Committee, that there is no need of such a draconian law, should be enforced and the law should be taken back. This is very important. The name of the activist is very important. Such type of question are now coming in Clat examination, as we have seen in Clat 2021. They are asking any question. So the name of the activist is very important, and the 2 committee, that is the one is the commission and another is the committee. These are very 2 important things that you have to know. Now next slide, that is the last slide, I guess. What is important, guys, the central government has to take into consideration the decision of the Supreme Court or the Jeevan Reddy Committee, and slowly as we have seen, it has removed it from some areas, and the central government with the state government has to coordinate and remove AFSPA from all this area, because it is a wide draconian law, just like Article 124A. that it give a very wide power to the security forces. Okay guys, so what this all thing you have to know from AFSPA. You have to know from which area it has been removed, in which area it is still there, when it was introduced, the different three ordinance and the act, and finally the present act, what power it is given, why there is a protest against it, the three committee, the activist name. That is the only the things that you have to remember from this thing. I hope it is clear to everyone guys. Let me know in the chat box.